This hearing is regarding the appeal made by Tangents Mango. This hearing is held at IRB office, Toronto on August 8, 2020. My name is Amanpreet Singh. I will be deciding your appeal. In this hearing, we will only be presenting and reviewing new evidence and nothing that has already been covered at the RPD hearing should be repeated today. May I ask appellant and appellant counsel to raise your hands? Do you solely affirm that the evidence do you give shall be the truth and the whole truth, nothing but the truth?
Yes, I do.
I do.
Thank you. The hearing has been called today to review the decision of the Refugee Protection Division made on the 21st of August 2015, disallowing refugee status for Mr. Tangents Mango and his two sons, Sonam Choke and Karma Tashwank. The applicant in his appeal has submitted some new evidences which the Refugee Appeal Division has allowed to be considered as the evidence did not exist at the time when RPD rejected the applicant's claim. Applicant is represented by Himmat Barar. In this hearing, we also have Gagandeep Singh as a minister's counsel. I will be asking questions and my questions are for the purpose of gathering information to allow me to make a fair decision about your appeal. If any question is unclear, please say so, and the question will be restated and rephrased. I will now ask the appellant a few questions. What is your name?
Sir, my name is Tangent Sagmo.
What is your marital status?
I'm married, sir.
Do you have any children?
I have two sons. Their names are Karma Swang and Sonam Choke.
What is your nationality?
I'm a Tibet national living in exile in India.
What is the nationality of your children?
My children are also Tibet nationals living in exile. They were born in India.
Do you have any proof of Tibet nationality?
I have a green book. This is the legal document issued by the Tibetan government in exile. I also have the registration certificate that is issued to Tibetan refugees in India by the government of India.
Do you have a proof of residence in India?
The proof of residence address that has been issued to me by the government of India is the registration certificate.
How did you come to Canada?
I traveled to Canada by air and traveled on a forged passport.
Do you have any criminal charges or convictions from previous state countries?
No, I don't have any criminal charges or conviction in India or Tibet.
Do you have any history of war crimes, terrorism, or organized crime?
No, I don't have any history of war crime and organized crime.
Okay, this is all I had to ask the appellant. I would now request the appellant's counsel to present new evidences. The applicant counsel may now proceed with the presentation of the new evidence for the consideration.
Thank you, Mr. Member, for granting permission to present new evidence that did not exist at the time when Refugee Protection Division rejected the refugee claim of appellant, Mr. Tenzing Sangmo. Mr. Minister, I would like to present Exhibit 1, which has been submitted already, an article in a renowned news publication in India, Bangalore Mirror. The heading of the news article is "She an Indian or Tibetan Citizen?" It is the harrowing experience of a lady whose nationality was questioned while after living on Indian passport in Switzerland for 11 years. This article talks of the plight of the Tibetan refugee Sipal Dikhi, who was born on the 9th of April 1986. Sipal Dikhi had applied for Indian citizenship and obtained an Indian passport as per provisions of Indian law. On the night of December 18th and 19th, 2013, Sipal Dikhi was arrested when she was about to board a plane to Switzerland. Sipal Dikhi was stopped by the Indian Immigration Bureau. and was arrested on charges of wrongly obtaining a passport and using it to live in Switzerland from November 2, 2000 and right up to January 29, 2011 for 11 years on an Indian passport. Sipal Dikhi, his advocate, told the court that Sipal Dikhi was born in India on April 9, 1986, and the Delhi High Court judgment that said all born in India before July 1, 1987 automatically become citizens of India applies to Dikhi's case. The Additional Solicitor General of India, Mr. Krishna S. Dikshit, said that the Delhi High Court judgment was sweeping and giving it a broad interpretation would mean a child born in India to a foreign traveler would also be considered an Indian national. He also said there are larger issues involved for the court to decide. This ruling came even though the law requires children of Tibetan refugees in India to register themselves as foreigners once they attain the age of 16. They are issued identity certificates for travel abroad and not Indian passport. The law says that anyone born in India after the Constitution came into force on January 26, 1950, becomes an automatic citizen even if his or her parents are not Indian. Later, of course, the cutoff date was pushed to July 1st, 1987. Those born after that were not considered automatic citizens unless one of their parents were Indian. Mr. Member, I would now like to present the other evidence, Exhibit 2, which has also been submitted to the board. This is a letter from Mr. Annapurna SS, dated February 19th, 2016. Mr. Annapurna is a member of the Mudgod Bar Association and was asked for an opinion by the appellant's wife. In this letter, Mr. Annapurna states that since the principal applicant does not have acceptable evidence to prove that she was born in India, she should not be entitled to become a citizen of India. He also states that Tibetans are not treated as automatic citizens of India even if they have evidence to prove they were born in India. Since Tenzing Sangmo does not have acceptable evidence to prove that they were born in India, he would not be entitled to become a citizen of India. Furthermore, Tibetans are also not treated as automatic citizens of India even if they have evidence to prove to have been born in India. That is all I had to present, Mr. Member. Thank you.
Thank you, Mr. Brad. Would the minister like to ask any question to the appellant?
Thank you, Mr. Member. Yes, I do have a few questions with the appellant. Hello, Mr. Tangent. I have a few questions for you. My first question for you is, why have you still not applied for Indian citizenship?
For Tibetan refugees, getting an Indian passport is almost an impossible task. India is a very corrupt country, and the government machinery that tries to extract bribes at every step. Court procedures are very lengthy and expensive and beyond my means. I do not have any ration card or Aadhaar card, which is necessary to obtain citizenship. With the new nationalist government in India introducing the NPR and CAA, which is the Citizenship Amendment Act, over 1 million Indian citizens have been disenfranchised because of their religion and non-availability of birth certificate of their parents. At a time when Indian citizens are being disenfranchised, I cannot imagine what I will have to get Indian citizenship. Also, my parents and a lot of refugee status since 1959 continue to maintain their refugee status, even in the face of many hardship. By taking up Indian citizenship, I would end up watering down all that every member of Tibetan refugees in India stood for and the sacrifice of over 1.2 million Tibetans who have been killed or lost their life at the hands and misrule of People Liberation Army.
All right, Mr. Tangent, have you ever considered moving to People Republic of China?
I guess over my dead body. Going to Tibet would mean incarceration, torture, and certain death at the hands of PLA. I would much rather self-immolate like hundreds of Tibetans have done in Tibet rather than face such misery.
All right, Mr. Tangent, I have checked your memorandum. In your memorandum, you mentioned your safety will be jeopardized if you go back to Tibet. Whom do you fear?
I am a follower of the spiritual and political leader Dalai Lama. Since 1958, PLA soldiers have started attacking Buddhist monasteries, killing monks and people who live there. My parents lived in a very fearful environment and fled to India to save my life. The situation has not changed in Tibet. I am afraid if I go to Tibet and fear being I will be arrested, tortured, and killed gruesomely or incarcerated in a dungeon or forced into labor camp, as is being done with millions of Tibetans and others Uyghur Muslims in China.
All right, Mr. Tenzin, have you or your family been mistreated or harmed by authorities?
Yes, Minister Council, I can recall numerous incidents where my family and close friends were mistreated and tortured based on our religion and ethnicity. People Liberation Army has killed, maimed, burnt alive, tortured ethnic Tibetans. So far, 1 million Tibetans have been killed by the People Liberation Army because they do not follow the ideology of Chinese Communist Party.
All right, Mr. Tangin, I have a same question related to the last question. You have lived in India since your birth, like in 1973. Have you ever been mistreated in India?
Minister Council, I lived in India on a registration certificate, which Indian government permits to Tibetans and renewed annually. There is a serious possibility of persecution in India by reasons of race, religion, nationality, and political opinion. With the introduction of Citizenship Amendment Act and NRC, the nationalist Indian government stripped almost 2 million Indians of their citizenship in 2019, and in the process of building concentration camp to house people stripped of their citizenship. I suffered discrimination while living in India, and if my registration certificate are not renewed by India, I could be put in these concentration camps that are coming up.
All right, Mr. Member, I'm done with my questions.
Okay. The appellant counsel may now present a closing statement.
Before that, Mr. Counsel, I have some concerns. Like in 2009,
No problem.
there is a Namgyal Dolkar versus Government of India, Ministry of External Affairs. The High Court of Delhi found an ethnic Tibetan born in India in 1986 to be an Indian citizen by virtue of birth, and to be thus entitled to an Indian passport. The court further held that a person who is an Indian citizen by birth is not required to apply for citizenship, and the court...
India is a corrupt country, and getting a passport many roadblocks. They have
Mr. Tangent,
a person of Tibetan origin for traveling on Indian passport that was legally procured under Indian laws.
Mr. Tangent, please do not speak without permission. Please treat this as a warning.
I apologize for this. I've run out of word.
Okay. Minister Counsel, do you have any questions?
No, I'm Mr. Member. I'm done with all my questions. You can proceed further.
Mr. Himmat, do you have any questions?
None right now, sir. I would only wait for permission to do the closing statement.
Okay. Now you are allowed to do a closing statement. Then I'm going to summarize and give a final decision.
Thank you.
No.
Mr. Member, the appellant meets the requirements of convention refugees as they have a well-founded fear of persecution in their country of origin because they are followers of the Dalai Lama, the Tibetan government and the Tibetan government in exile in India. The principal appellant has testified that he is a follower of His Holiness, the Dalai Lama, and believes in a free Tibet. Documentary evidence shows that the appellant would face serious possibility of persecution by the PLA in Tibet if they were to return. The Indian Citizenship Act 1955 defines the acquisition of Indian citizenship by birth. The Act clearly states that a person born in India between 1950 and 1987 is an Indian citizen by birth, irrespective of the nationality of his parents. The inability of Tibetans, even those born between 1950 and 1987 in India, to secure citizenship has not changed despite High Court decisions holding that Tibetans born between those years are entitled to citizenship. Mr. Member, the two lawyers' letters which follows the rejection of the claim presented as evidence clearly says that the Tibetans are not treated automatically as citizens of India, even if they have evidence to prove that they were born in India. Furthermore, RPT did not consider the minor claimant's situation of being Tibetan born outside the operative timeline, that is, July 1987. Both the minor appellants were born after July 1987, and in order for them to be Indian citizens, one of their parents has to be an Indian citizen. Both parents have been living in India using a registration certificate that is issued to Tibetan refugees in India. Living on this document also keeps them outside the ambit of a citizen's privileges, which include medical care, subsidized rations, and fuel, as also restricts their movement and rights to ownership of property. The minor appellant's path to becoming Indian citizenship has a major obstacle that both their parents must apply for and be granted Indian citizenship. Mr. Member, the appellant has submitted new evidence that arose after the rejection of their claim or was not reasonably available at the time of rejection. Mr. Member, the country condition of the People's Republic of China speaks of gross human rights violation in the past and present. Large number of Tibetans starved to death, have been tortured, incarcerated in internment camps, burnt alive, and the demography of the region has been changed in a planned fashion. Chinese troops systematically raped, tortured, burnt, murdered Tibetans, and destroyed their mosques. The number of facts and evidence provided clearly demonstrate that principal appellant and minor appellants are convention refugees. Please consider if they return to their country of origin that they will face systematic persecution. This persecution will be based on their religious beliefs and ethnicity. Please note, the appellant cannot live safely in India either. There will be a continuous threat to the family. Discrimination faced in one specific state, Karnataka, where appellant resides in India, exists in every state of India. There is clear evidence which shows that the appellant will be unable to obtain Indian citizenship. The racism heat map produced by Washington Post in 2013 shows India as red hot. With regards to subjective fear, please consider the factor appellant cannot return to his country of origin because of persecution. Mr. Member, we are asking to consider all the facts and evidence provided in the memorandum, situation of minor appellant, and allow the appellant under Section 96 of Immigration Refugee Protection Act as convention refugee. Thank you, Mr. Member.
Okay, I thank everybody to give their opinions. Now I'm gonna give my final decision. In my view, a country of nationality includes a country where the claimant is a citizen and where the claimant may face an insignificant impediments to accessing state protection from that country, but may not include a country where the claimant is a citizen and faces significant impediment to accessing the state protection from that country. In this case, the principal applicant shows evidence that he does not have acceptable proof of being born in India. And as a result, he would not be able to access Indian citizenship and that he would have to legitimate to get her citizenship. The applicant produced a letter from R&H, a lawyer that was in evidence before the RPD. This letter is dated February 5, 2014. This letter states, now our Supreme Court has given a decision that the Tibetan citizens who were born in India are eligible for getting Indian citizenship. But acquiring Indian citizenship is not at all so easy. The Tibetan person who wants to get the citizenship of India must apply before the concerned authorities. Identity cards, ration cards, and passports are not issued to the Tibetan citizens, which are very important documents to get citizenship as they are treated as refugees. If the Tibetan person intends to get the Indian citizenship, he must approach the concerned court. The court procedures are also very lengthy and very expensive. At the end, there is no guarantee that the court shall grant an order for getting Indian citizenship. This is also a new evidence in the letter from another lawyer, Sir Mr. Anupurma, dated February 19, 2016. The letter states that the writer of the letter is a member of Mangote Bar Association, and he was asked by the principal applicant for an opinion on his and his family's right to Indian citizenship. He states that since the principal applicant does not have acceptable evidence to prove that she was born in India, she would not be entitled to become a citizen of India. He states that furthermore, Tibetans are also not treated as automatic citizens of India, even they have evidence to prove they were born in India. The letter states that the author is a lawyer and a member of Mangote Bar Association and member of state Karnataka, India, and familiar with the situation of Tibetans in India. Since Tenzin Mango does not have acceptable evidence to prove that they were born in India, he would not be entitled to become a citizen of India. Furthermore, Tibetans are also not treated as automatic citizens of India, even if they have evidence to prove to have been born in India. Given the fact that Tenzin Mango is not a citizen of India, their children named Karma Taswang and Sonam Choke do not have the birth rights to citizenship, even they were born after 1987. The RAD notes that the response to information request states that in the Delhi court case, regional passport authorities have refused the petitioner who born in 1985 to Tibetan refugees in India a passport on the basis that individuals born during 1950 to 1987 cannot automatically be treated as Indian citizens under Citizenship Act and must apply for citizenship under Section 9(2) of the Act. The RAD notes that the NDP states, according to the source, that the authorities argued that the petitioner have listed Tibetans as his nationality while applying for his passport, which prevented them from issuing him an Indian passport. The RAD also notes that the IR states that the 2013 ruling by the Karnataka High Court promoted the Elections Commission of India to direct all states to include eligible Tibetan in the voter registration list for the 2014 to 2015 elections, especially Tibetan born in India between 1950 and 1987, and that some eligible Tibetan exercise their right to vote. The RAD also notes, however, that the Ministry of Home Affairs is against the decision by the ECI to grant voting to Tibetan born in India, arguing that if Tibetan born to vote, they must apply for the Indian citizenship because they cannot have the status of refugees and citizens at the same time. The RAD notes that the position of the MHA implies that citizenship would be granted to those willing to give up their refugee status. The RAD notes that, however, according to the same IR, some Tibetan are not in the favor of giving their refugee status and acquiring Indian citizenship rights because it would signify a lack of commitment to the Tibetan cause. The RAD finds that on the balance of possibilities, the applicant have shown significant impediment that may reasonably be considered capable of preventing them from exercising their state protection rights of citizenship in India. The lawyer's opinion are evidence that the applicant have made reasonable effort to overcome the impediment, including the information that in all likelihood, the principal applicant would not be successful in an application to the court. After looking at documentary evidence provided by the applicant, it is clear that if applicant is returned to their country of citizenship, Tibet, they would be prosecuted as ethnic Tibetan and follower of His Holiness the Dalai Lama. Moreover, on the balances of possibilities, the applicant has shown significant impedance that may reasonably consider capable of preventing them from exercising their state protection rights of citizenship in India. The lawyer's opinion are evident that the applicant have made reasonable effort to overcome the impediments, including the information that in all likelihood, the principal applicant would successful in an application to the court. On looking at all the facts and ground, this appeal is allowed pursuant to section 111B of IRPA. The determination of the RPD is set aside, and I substitute a determination that, in its opinion, should have been made, namely that applicants are conventional refugees. Thank you.
Thank you, Mr. Member. I win.